Dear students, welcome to EPG Pasala. I am Dr. Alagamani, Professor of Agricultural Economics, currently heading the Department of Trade and Intellectual Property, Center for Agricultural and Rural Development Studies, Tamil Nadu Agriculture University, Coimbatore, Tamil Nadu. In this module, I will introduce about the intellectual property and important organizations relating to the intellectual property, how to get the patent, and also what are the importance, how to commercialize, all those things I will be discussing. So intellectual property assumes importance after the formation of the World Trade Organization. Globally it regulates the trade. World Intellectual Property Organization, it is one of the United Nations organization established in the year 1967. It has defined intellectual property as the creations of the mind, inventions, literary and artistic works, symbols, names, images and designs used in commerce. Broadly, we can classify the intellectual property into two categories. One is relating to the intellectual property, another one industrial property, another one is relating to the copyright related properties. Industrial property includes patent, industrial design and trademarks. All these are having industrial applications. The next category is copyright law, which includes literary, dramatic and artistic works, and also performing the various programs and rights relating to the broadcast in the radio and television programs. Intellectual property, it is a collective term. It includes several instruments of IPR, that is intellectual property rights. The first one is patent, copyrights, trademarks, registered industrial design, protection of integrated circuit layout design, geographical indications, protection of undisclosed information. This can also be referred as a trade secret. Then protection of plant varieties. Patent is one of the instrument used to get the intellectual property rights. It is an exclusive right granted by the country to the owner of the invention. It means to make, use, manufacture and market the invention. The owner can do it and he has to satisfy the law and the specification mentioned in that. Exclusive right means others are not entitled to manufacture, using or marketing the invention. This right is available for limited period of time. So patent, as per the law, it is like any other property. So it can be gifted, inherited, assigned, sold or licensed. Since the patent right is territorial in nature, that is, if a country grants patent, it is applicable in the particular country only. So it means, that is, India is giving patent or intellectual property rights means it can be enforced in that country alone. Then all the rights conferred by the state. So if suppose some circumstances, it may be revoked by the state, provided even if it is sold, licensed, manufactured or marketed in the meantime. So as per the law, a invention can be patented, some things cannot be patented. So any invention can be patented means it should satisfy some other criteria. Invention is available for a new product and process, provided a new or inventive step is involved in it and it has an industrial application. The three important criteria are novelty, inventive step, industrial application. First we will see about the novelty. Novelty means it should not be made, published anywhere, or it should not be discussed in any seminars or workshops. So it should be new, it should not be known to anybody. Then inventive step means comparing the previous any process is available, it should be new. It should not be obvious to the persons, those who are skilled in the particular art, based on the prior publication or documents. Industrial application, that means it should possess the utility. It should be made or used in an industry, that is mass multiplication should be possible and it should be passed on to the economy, it should create the economic wealth. There are few examples I have given what are not patentable. If some invention which are contrary to the established natural law, you cannot go for patent. If the invention is primarily or intended to use or commercial exploitation of which is contrary to the public order or morality, which causes serious prejudice to human, animal or plant life or health or to the environment, it is not patentable. And also mere discovery of some of the principles, formulas, formulations, then some of the theories, discovery of any living thing and non-living substances occurring in the nature are not patentable. Some of the processes which are very useful for human beings, especially for the treatment of any diseases and also animals, it cannot be patentable. For example, process for medicinal, surgical, curative, prophylactic, diagnostic and therapeutic treatment of human beings are not patentable. Plants and animals as a whole or any part other than the microorganisms are not patentable. Any invention which is a traditional knowledge or it is a duplication of the known properties or traditionally known component are not also patentable. Some of the inventions which are relating to the atomic energy are not patentable. Patent Act is passed each country according to the requirement, but after the agreement, TRIPS agreement, Patent Act was amended. In India, 1970 Patent Act was amended several times, and finally Patent Amendment Act 2005 is in force. Then rules are framed in the year 2003 and the rules are amended in the year 2006 and it is effective from 5/5/2006 onwards. Then coming to the administration of the Patent Office is coming under the Ministry of Commerce and Industry. It is governed by the Department of Industrial Policy and Promotion. They are facilitating the inventions and registration of the patent and industrial designs. The regional offices located in Kolkata, Mumbai, Chennai and Delhi, they receive applications originating from their territory because each office is having the territory of the particular country. Then what are the contents in the complete specification? It should be it should start with the title, field of invention, then background of the invention with regard to the drawback associated with no knots, then object of invention, the statement of invention, summary of invention, a brief description of the accompanying drawings, a detailed description of the invention with reference to the drawings and examples, claims, and finally abstract. Claims and abstract should be given in a separate page. The specification must start with the invention title. The title itself describes the general nature of the invention. It should not contain anyone's name or fancy name, a trade name or personal name or any abbreviation. Application is required to be filed according to the territorial limits. Already I said. The territorial limit means it indicates the person where the inventor where he resides or she resides or the place of invention or the place of business. It should they have to file according to the territory in the patent office. Then what are the documents to be accompanied in a patent application form? So application form is in the form number 1. So it should be submitted in duplicate. Then specification should be given in the form number 2. It may be provisional or complete specification. If the provisional specification is filed, already I said, the complete specification has to be filed within 12 months from the date of filing of the patent application. Then drawings, then abstract of the invention, then information and undertaking listing the number, filing date, current status of each foreign patent. Then it should be given in the form number 3. So suppose someone has filed a patent in another country and if they want to file it in another country, this form has to be used. Then priority document. Suppose they have filed in another country, the state or country in which it was applied, that date is taken as a priority date. Then declaration of the invention, it should be given in the form number 5. Then suppose if the patent is filed through the patent agent, then power of attorney has to be given. Then all the applications, it should be accompanied with the fees that is prevailing in the particular time. It may be paid in cash or by check or DD. It should be payable to the controller of patents. Then having applied, then what next? What they will do in the patent office? So patent office, after receiving the application, scrutinizing the application, if everything they feel it's complete, and the fees also they will check it according to the number of pages, the fees will be collected. Then if everything is found correct, then it will be published in the patent office journal after 18 months from the date of filing. So the publication includes the date of application, application number, name and address of the applicant, abstract. So abstract, already I said it should be given in a separate page along with the title, and it should be in a brief. It should give all the information about the innovation or invention. So before the publication, the application for the patent are not open for inspection by any public. Then request for publication. Suppose anybody is interested, any innovator, he is capable of selling it or commercializing it or want to use it very quickly, then they can go for requesting for earlier publication. The form number 9 has to be used for it along with the fees prescribed. If the request for publication is submitted, then the application will be published within a month from the date of receipt of the request. Then from the day onwards, then the inventor is having the provisional rights. The request for examination. You have filed the application, you have made a request for publication. Suppose if you want to examine, then what you have to do? Then you have to go for using the form number 18. Automatically any patent application will not be examined. So you have to give the request for examination in form number 18. Then it should be within a period of 48 months from the date of priority application. That is, we can say roughly 48 months means it is 4 years from the date of filing the application, whichever is earlier. If no request is made, the application will be treated as withdrawn, or the application cannot be revived thereafter. So I think now you could able to understand the importance of the giving request in form number 18. Unless you give the request in the form number 18 along with the prescribed fees within a period of 48 months, your application will not be examined. Your application will be treated as withdrawn. Further, you cannot revive it also. Then examination. The patent office will appoint a suitable person to examine the patent application. Each application, after receiving the form number 18, the numbers will be given according to the serial number. Examination will be conducted, and the first examination report will be given in the form of a report, that is FER. So for this report, it may contain some modifications, some objections or requirements. It will be communicated to the address given for service or communication. So the patent applicant has to reply within 6 months from the date of first examination report. Otherwise, this also will be treated as abandoned. So you cannot revive it. Then coming to the, once you have filed the application, whether there is any possibility for withdrawal of the application. Sometimes some of the inventors may be interested in withdrawing the application due to some reasons. It may be administrative or technical reasons, or they may want to improve it. In such a case, there is a provision for the law. So if the publication is made within 18 months from the date of filing, you can withdraw the application 3 months before the first publication, or whichever is earlier. Suppose if you have withdrawn the application, after some time you can go for filing the application. Once it is published, you cannot refile it. Hence, if you want to refile it by improving the innovation or patent application, then you can do it. Then once it is published, you cannot refile it because it is known for the people, it is open for the public. Then grant of patent. So first step, application of the patent application along with the specification, then publication is done. The next is first examination report, then you have given reply. If the patent office is satisfied with all the requirements of the first examination report, or if there is some opposition for the grant of patent and if the reply is suitably given, if the authorities are satisfied, the patent will be granted. The letter of patent is issued after entering the register of patents. Then finally it is notified in the patent office journal. So once it is patent is granted means, then if any public is interested in seeing the document, by paying the prescribed fees they can go through the application and inventions. Then what is the period the protection is given? That is called the term of patent. It is 20 years. Previously in India it was only 14 years. Now universally the term of patent is 20 years. So the 20 years starts from the date on which the application is filed. The renewal fee. To keep the patent in force, renewal fee is to be paid every year. So normally after the grant of patent, in accumulative form we have to pay the fees, otherwise it won't be ineffective. If the renewal fees is not paid within the prescribed time, the patent will cease to have effect. Then there is a provision to restore the patent also. It has to be done from the 18 months. The time given is within 18 months we have to resubmit it. Then compulsory license. So for grant of any patent, already in the introduction I have mentioned, it has to be converted into a wealth or asset of any industry. So patent is given by the government for industrial development, and it is the mandatory for the patentee to work with the patent on an industrial scale, that is mass production, and making it available to the public at a reasonable rate. Sometimes it may be abused by the patent right holders, hence there is a provision that is called a compulsory license. Suppose the patent which is very useful, which is not made available to the public, means any person who are having the capacity to manufacture in a large scale, they can go for applying to the patent office to get the license, compulsory license. So the compulsory license will be given only after expiry of 3 years from the date of sealing of patent rights. That is, if the patent is given in July 2017 means, then it is the compulsory license can be granted after 3 years, July 2020 only. If the particular compulsory license holder can able to multiply and he can make it available to the public means, state or the nation can revoke the grant of patent rights. Then coming to some of the inventions, there are which are relating to agriculture or some botanical inventions which may use biological material. If it is described in the specification, so in the provisional specification or complete specification, we have to give the details about the materials used in the invention. If such material is used, it has to be deposited in the competent authority. So deposit has to be made in the International Depository Authority on or before the date of filing. So in the Chandigarh it is available, Microbial Type Culture Collection Gene Bank, MTTC. So you can go for filing it. IPR in the National Biodiversity Act. So in all biological materials are protected or governed by the National Biodiversity Act 2002 in India. So anybody who goes for protecting the innovation or getting a patent, if they have used the biological material, then they have to get the approval from the National Biodiversity Authority. So they have to give the request in form number 3 with all the details where the biological materials are used. So especially for Indian context, National Biodiversity Authority office is located in Chennai. Then they have to pay the fees and also submit the details in the form number 3. then National Biodiversity Authority will give the approval in the form of a written agreement which is signed by both the National Biodiversity Authority and the applicant. Sometimes they may reject the application by giving the reasons, and also they give the inventor chance to give the explanation also. The biological resource, what does it mean? As per the Biodiversity Act section 2C, plants, animals, microorganisms or parts thereof, their genetic material or byproducts with actual and potential use, but it does not include human genetic material. So it includes all the plants, animals and microorganisms excluding the human genetic material. So these are referred as biological resources as per the Biodiversity Act. Then, having obtained the patent or protection for your intellectual property, what next? It has to be commercialized. Either you can start your own company or you can transfer it for commercial purposes by licensing or by understanding, by negotiating with the buyer. You can do it, or you can receive the royalty also. Then Patent Cooperation Treaty, PCT. So it is having seen the patent application at a national office and what are the procedure to get the patent. Now we will see about the international phase. What is possible if you want to go for filing the patent in the international level or some more countries. So Patent Cooperation Treaty is one such arrangement which is coming under the TRIPS, that is trade related aspects of intellectual property rights. So their main aim is international cooperation. This is a treaty for rationalization and cooperation with regard to filing, searching and examination of patent applications and dissemination of the technical information. Then what are the salient features of PCT? One single application in one single language is filed in a single patent office. So this has an effect on filing on the same day, that is priority date in other countries or some other country the applicant want to have the protection. Then one formal examination. It is done by the office in which the patent is filed. The application is subjected to international search. This results in a report citing the relevant prior art. So some of the documents which are relevant to the current invention may be given in the report. Then centralized international publication will be done along with the reports. Then there is an option for preliminary examination also. So after this they will give the report which gives the details on international criteria for patentability. So by seeing this report you can come to a conclusion whether the invention is patentable or not. Then what is the time period within which it has to be filed? The PCT international application can be filed within 1 year from the date of filing the national application in home country. Suppose the inventor is an Indian, he has filed a patent in India, then he has to submit the international application within 1 year from the date of filing the application in the home country. So it can be filed directly, that is international application can be directly filed with International Bureau, that is World Intellectual Property Organization located at Geneva, Switzerland. It is a receiving office. It can be submitted in any one of the 10 languages which are listed in the Patent Cooperation Treaty, that is Arabic, Chinese, English, French, German, Japanese, Korean, Portuguese, Russian or Spanish. Any one of the languages it can be written and it can be filed in the WIPO office at Geneva. Then preliminary examination, again just like national phase, the preliminary examination has to be requested before 19 months from the international filing date or priority date, whichever is earlier. So once you get the patent in one particular country, you can get the patent in some of the countries in which the patent is having the commercial application. And recently, Director General of WIPO, Francis Gray, he said he has come to India for attending the workshop on enforcement of intellectual property rights in India, which is held in August 2017. So he has commended the initiatives taken by the Indian government. Especially, he said India has taken groundbreaking initiatives both at the national and at the international level in the area of intellectual property. These initiatives are mainly aimed at creating empowering environment, that is empowering environment for intellectual property. We have to create an environment so as the intellectual property rights will be protected. So this will help the India in many of the initiatives taken for the country's development. Then intellectual property is to be an empowering mechanism. It has to provide business and industry with tools that enable to convert the intellectual and cultural richness of any country into the economic wealth. Then it has also to provide tools to enable industry and commerce for preventing the unfair and predatory practices that deprive creators, inventors and entrepreneurs of this possibility of converting intellectual and cultural richness of India into commercial assets. Commercial assets means actually it is a creation of economic wealth for the nation. So intellectual property definitely should lead to the prosperity of the economy. This is most important. Having realized this, almost all the countries in the world, especially 191 countries, have become the members of the WIPO organization, that is World Intellectual Property Organization. All the countries are involved in the prosperity. So hence they have made the intellectual property as a law and also amended according to the international requirements. So having seen about the intellectual property and patent, now I am going to summarize what we have learnt in this module. So in this module we have covered the World Intellectual Properties Organization's definition of intellectual property. So we know that it is a creations of the mind. Just like any other property, this can also be patented. That is, you can get the protection for the intellectual property as patent, copyright, trademark, etc. So in this module we have seen about mainly the patent. How to get the patent, what is patentable, what is not patentable. So patentability especially it covers three criteria: novelty, inventive step and industrial application. So if you have any intellectual property, you can go for protecting by application to the patent office in the regional offices. So in India we know that there are 4 important regional offices. According to the residents, you have to go for application. This is applicable to everywhere in the world, especially after the formation of the WTO and signing the TRIPS, trade related intellectual property agreement. Globally, patent laws are similar and the features are also similar. So once you have filed a patent in the Indian office or any native country office, you can go for the international protection of patent.